Good day. My name is Babak Shamsi. I'm one of the lawyers here at Beresford Booth, working in the litigation and real estate groups. I'm the chair of the real estate group here at Beresford Booth. I appreciate you coming and taking the time to watch this presentation that I've prepared. And I'll be going through a number of different slides here, and their slides should be up so that you'll be able to see them as I go along. And I hope you find this presentation informative today. As you know, Beresford Booth is a full practice civil firm with practice areas in real estate, business, estate planning, family law, and litigation for all of that. And so my focus here is predominantly on real estate and then also various types of litigation, including real estate and law real estate matters. So today's presentation is on the methods of establishing an easement, something that we deal with all the time, both in terms of creating easements, terminating easements, negotiating easements, and of course, litigating over easements. So let's start from the sort of 101 of what easements are. What are easements? Well, an easement is a non-possessory right to use or enjoy someone else's land. In other words, an easement gives the holder of the easement an ability to perform certain acts on another person's property, but not actually an ownership interest. So in a sense, it's a right to use someone else's property, but not to own it. The party that enjoys the use is often called the benefited party or the grantee, and the party who owns the property subject to the easement is often referred to as the burdened party because their property is burdened by the easement, or the grantor. There are two major categories of easements, and I'll get into each of these in some examples. There are further examples of those two types of easements. But there are pertinent easements, which benefit a specific piece of real property. This is most common. This is, for those of you watching who know about easements, this is probably what you're thinking of when you're thinking of an easement. It's an pertinent easement. But there are also easements in gross, which benefit a specific grantee rather than a specific piece of property. This is less common, but still in play and still important these days, and I'll get into sort of examples of that. So I'm going to start with easements in gross. RCW 6465010 defines an easement in gross as an easement not tied to or dependent upon ownership or occupancy of a unit or a parcel of real property. So for an easement in gross, again, the benefit goes to a specific party, not to a piece of land. So this is not the situation where your neighbor has an easement, across your property or vice versa or something like that for purposes of, access or ingress or egress or parking or whatever it may be. This is not that type of situation. This is linked to a party. And indeed, unless the easement specifically calls it out, the rights to the easement can't be transferred. And it doesn't depend on property ownership. So the grantee of the easement is the grantee, and typically they're the only grantee. And so once I discuss some of the common examples, it will start to make sense. Easements for public roads, utility lines, railroad rights of way, right to extract minerals. Oftentimes it's common to grant an easement in gross over to a utility company. So for example, Seattle City Light or utility companies or Comcast might have an easement to a person's property for purposes of servicing and maintaining, establishing, whatever they need to do in order to provide the service. This also happens with sewer lines. Sometimes we'll have an easement in gross for like a sewer company or water district to do maintenance work or something on private property, but they're not an adjacent property owner. They're not a property owner that lives nearby that has some sort of need or reason to have access onto your property. They're a separate entity. Oftentimes they are, they are often governmental organizations, quasi-governmental organizations. But this is what, we're talking about when we're dealing with easements in gross. Easements in Washington State are strongly presumed to be pertinent and not in gross. Easements in gross are generally disfavored in the courts, and by and large, most easements are not in gross. So you don't see this all the time, and if you do see this, it's usually some rather large entity that is getting an easement in gross for a specific service that's ultimately being provided. Then there are pertinent easements. RCW 6465010, again, defines an pertinent easement as an easement tied to or dependent on ownership or occupancy of a unit or parcel of real property. This is what Washington state courts presume easements to be. Most of them are pertinent easements, and they involve properties that are located adjacent to or very nearby to each other. Again, because this is often involving neighbors or neighborhoods that have easements with each other. Frankly, a property owner in Kirkland is not typically going to need to have an easement over a property located in Seattle, right? That's not really the purpose of an easement. So it's usually within, most of the time they're directly adjacent with the pertinent easements, but sometimes you have them in like a neighborhood. Think like an easement that goes across, there's like a private road and everybody has easements to, this private road goes across multiple properties and people have easements, to the different properties, and so they can access their own property. And maybe they have to go through 2 or 3 properties to get there. There should be, easements potentially for all of those to establish that kind of access, right? So property owned by the burden party or grantor, again, is referred to as the servient estate. And the property owned by the benefited party or the grantee is referred to as the dominant estate. These terms come up all the time in the case law, even in documents themselves, Google searches and AI searches, if you're doing that these days too. You will hear those terms thrown around, so it's useful to know what they mean. Pertinent easements typically need to be recorded and usually last in perpetuity. Not always, actually. Sometimes there are term limits on them, but usually they just last until, for some reason they fall out of favor or need to be terminated specifically for some reason. They'll just go on and they will run with the land, which is another thing, is that a pertinent easement typically is not only recorded, but when a property owner has an easement, they sell their property, the easement doesn't go away. The easement continues and is transferable because it goes with the property. It doesn't go with the specific owner, right? So when the property is sold, whether it's the burdened property or the benefited property, the next owner who comes in is going to continue to enjoy the rights to that easement. In most circumstances, when we're talking about permanent easements, there are exceptions, numerous exceptions that we won't get into today. But nonetheless, it comes up on a fairly regular basis, and having an easement run with the land, so to speak, is one of the most common characteristics that we see. So now we'll talk about a couple of common types of easements within those two categories. So with easements in gross, again, we're talking about utility easements, power lines, gas lines, sewer, drainage, stormwater. Again, think about where you need a utility company or quasi-governmental agency to do some work on your property to provide a service. That's what we're talking about there. There are also conservation easements. These are often used to protect critical areas, wetlands, can limit cutting down trees or mining. These are also fairly common, especially here in Washington State, where there can be often areas where it's been determined by a local government or some other entity that it needs to be protected. There may be these sorts of easements. And then this one's kind of funny. There can be private use easements in gross. I don't see this very often, but for example, you could have an easement that allows a particular person to fish in your pond in perpetuity. I mean, again, this is the sort of thing that begs the question of why wouldn't you just sort of give them permission to come do it? And then, when you don't want them to, stop giving them permission. But these do exist. They are rare these days, but there may be some other considerations out there for why you would want it to be an easement that runs in perpetuity. At least as far as that particular party goes, you would have this sort of a situation, perhaps a private use easement for us. And then you've got pertinent easements. I'd say two of the most common ones that I see are exclusive use easements. This is often where there's like a closed off piece of area that only one property owner uses, and the other property owner who actually owns that closed off area never uses it. And this will come up, for example, if a fence is in the wrong place and a fence like completely encloses an area. And so let's say I own a piece of property, but the neighbor has the fences in the wrong place, and so like 2 feet of my property is now made up of like the 2 feet closest to the property line to me are made up of like a garden that my neighbor's been using forever. Maybe I'll grant an exclusive use easement for that to just let them continue to maintain that garden, and that's basically theirs to use in perpetuity, including their successors, that kind of thing. And I never use it, and we'll get to this a little bit later in the presentation. nonetheless, just because it's an exclusive use doesn't mean you can't define the scope of that easement. And then ingress and egress is also really common in permanent easement. I had mentioned that a little bit earlier in the presentation, but basically, if you have to have access through your neighbor's property, a driveway, a walkway, for some reason to go through there to get to somewhere else, these sort of ingress and egress easements are common, access easements, if you will, very common in permanent easement that we see on a regular basis. So we'll get to how do you establish easements. There are a number of ways to establish easements. This presentation is going to go over four of them. I would say three major ones and one somewhat minor one. So there's the easement by express grant. This is what most people think of when they think of easements. They will think of a written document that has been prepared that hopefully outlines the terms of the easements. But if you go look, there are a lot of really poor easements that have been drafted that are just ripe for litigation, unfortunately. But most easements, when people think of easements, they think of easements by express grant. That is perhaps the most common, or indeed the most common type of easement. Written document recorded with the county establishing the easement. I usually see these in three different types. Easements on plat. This is where a developer has, developed the plat, various properties, and on the actual plat itself, it'll state that there's an easement that, for example, all the owners might have the right to use a specific lot for a purpose or a specific driveway for a purpose, and they'll outline that right on the plat. That's one place I've seen it. I've also seen easements by deed, where there's a statutory warranty deed and it'll actually outline an easement on it. In my experience, this is a really poor way to establish an easement, because easements that are only shown on a deed tend to have the tendency, if you will, to drop off over the years. So maybe they put it in a deed in 1978, and then all of a sudden in 1985 it's sold, and the next deed accidentally omits it, and then in 93 it sells again and it's still omitted, and then you find yourself here in 2025 trying to assert that there's an easement, and it hasn't been on the last four deeds, but it was on one back in the 70s, and you're now dealing with sort of the fallout from that. So not the best way to do it, but that is one way that express easements are found or established. And then the most common, I would say, and certainly the best way, is a standalone recorded easement, where this is what most people think of. It's a specific document that indicates what it's for, and is a grant of an easement from one party to another, one property to another, and recorded with the county. You've got easements by prescription. This is kind of like adverse possession, which a lot of people kind of sort of have just heard of in the air. It basically creates an easement over someone else's property through long-standing, continuous, open, hostile use of that property. And hostile is an interesting term I'll get to. But basically, this is where you have an easement because you've been using someone else's land for a long time in that fashion. And the law and the courts have determined that that's now an easement, even though there isn't a writing. There's easement by estoppel, which I'm not going to spend a lot of time on because this doesn't come up that often. But basically, it prevents a property owner from denying access to land where their actions and their conduct or their representations have led the other property owner to rely on and believe that they had that access. So basically, I take actions or say things that lead you to reasonably believe that you have an easement to my property, and then you rely on it, and your reliance could be a number of different things, but you rely on it to use my property as the easement, and then I turn around and say, oh no, you actually can't do that, and I try to prohibit you from doing it. This again doesn't come up a lot. It does come up from time to time. It requires some pretty specific and strong facts to get there. But it is, I have seen this established, seen this as one method of establishing an easement. And then finally, there's easement by implication. There's two types. There's an easement by prior use and an easement by necessity. And I'll explain those a little bit more later. So basically where there's an implied easement through those types of circumstances as opposed to, an express easement. So express easements, there's really a lot of considerations, and I've just put forth, a handful of them in terms of how establishing an express easement is best done. There's a lot of things that go into it. Unfortunately, like I said before, a lot of older easements, or even current ones, sadly, are just bereft of the level of specifics that you need to really protect yourself. And these can be an absolute landmine in terms of creating litigation. And a lot of the easement litigation that I have dealt with in my practice has actually been over poorly drafted easements. Believe it or not, that's more common in my experience than even those people who are trying to establish an easement by prescription or by necessity or something else where there isn't one. It's actually more often the problem not that there isn't an easement, but that there's just a terribly drafted easement. So some of the things to think about when drafting an easement: is it exclusive or non-exclusive? Again, it might be exclusive if it's an area traditionally only used by the grantee, like I was saying before, a garden, a yard area, something like that. Something where it just looks like the property line was in the wrong place. And no one would expect that that's where the property line was, and looks like it's your neighbor's property, but it's not. And so you've got maybe an exclusive easement could fit in that situation, depending on the circumstances, of course. Or do you have a non-exclusive easement, where the grantor, the actual property owner, needs to retain the right to use that easement as well? Again, driveways is a great example. A joint driveway, for example, could be one of those things where both parties need it. One party owns it, but both parties need to use it. A non-exclusive easement can sometimes solve that problem. Identifying the scope of an easement is very important. What is it for? If it's exclusive use, what exclusive use can be done? If it's an area where the neighbor has been gardening, can they now build a structure there? I mean, they have exclusive use. Can they do whatever they want with it? Or no, they can only have a garden. Or can they plant trees there? I mean, it's still nature. Can they plant trees instead of just having shrubs or flowers there? You can identify the precise scope of the easement, because by and large, a property owner can use the property subject to the easement so long as they don't interfere with the grantee's use of the easement. But in an exclusive easement, you really got to outline what the grantee can do with that property, because the grantor in that case can't do anything with it really, because it's exclusive use. And then, if we're talking about a non-exclusive or like an egress-ingress easement, for that example, what does that mean? Is it a walkway? Is it a driveway? Can you have gates? Can you have ATVs? Can you have vehicles, parking? There's all things to think about when drafting an easement. And again, this is one of the circumstances where I say hiring a lawyer is a really good idea if you're going to draft an easement, grant an easement, or get an easement, because again, most easement litigation I come across comes from easements badly drafted, and that is the real problem. Other things like, is there consideration for the easement? You might have excise tax if you're paying for the grant of the easement. Who remains responsible for property taxes is a big thing that comes up in these sorts of situations. I grant an exclusive easement to my neighbor. They're the one using the property, and I'll often hear, why should I pay the taxes on it? And there's a lot of considerations into that in terms of, calculating it and going and getting reimbursed for it and all those things. Responsibility for maintenance and repair is another really big one when granting an easement. In Washington State, the presumption is that the grantee, the one who is getting granted the easement, not the property owner, is responsible for maintenance, absent an express agreement. Is that what you want? That's another consideration that's really important. And then dispute resolution. I mean, the number of easements that actually have something in there about how disputes are resolved are minimal, which is shocking, but not shocking to me anymore. Do you want mandatory mediation, arbitration, litigation? Should you go get multiple bids on how to fix a driveway before you decide what to do with it? There's a lot of different permutations of that, but these are all considerations that we think about when drafting an express easement, and that I think are really critical to avoiding litigation down the road, because that's part of the point. I mean, the goal is to make sure that everybody understands what the scope of the easement is and what their rights and responsibilities are, and two, eliminate as much vagueness and think of as many of the permutations of what might happen as you can to avoid litigation in the future. Now we've got easements by prescription. Easements by prescription this is where you establish an easement over a neighboring property through long-standing use of their land. There are several elements of prescription. There's hostility, open and notorious, continuous, what I call exclusive, because courts kind of vary on whether they actually call it that, and it's not exclusivity in the way that in adverse possession, for example, you have to fully exclude another person from using the piece of property that they own in order to establish that you have a claim to that property. And adverse possession essentially is where you're claiming ownership over a portion of another person's property through longstanding use. You have to exclude them completely. Whereas here, it's not exclusive in that same sense, which I will explain. And then in some cases, there's the uniform route element. So hostility basically requires that there's use that's hostile to the interests of the property owner. Hostility is implied from facts. It doesn't require any sort of formal notice or anything like that. And hostility is not actual hostility. So oftentimes people think, well, I was being really nice about it, so I'm not sure I meet the element of hostility. That doesn't matter. The subjective intent doesn't even matter. It used to, but the courts overturned that a long time ago. Now it's just a matter of, are your actions technically actually hostile to their property owner interest? If the fence is in the wrong place and I've been using 5 feet of their land for 25 years, and I've been doing it regularly, and I've just been using their land, even if I didn't mean to do that in the sense of I wasn't aggressively like, haha, I'm going to take their land. That hostility element may be met. It's not really about actual hostility. There's open and notorious use, and I'll say hostility is one of the elements that gets litigated perhaps the most. Second is open and notorious use. This is just to say that the use has to be open and obvious. You don't have to have, the landowner, doesn't have to have actual knowledge that it's happening, but it has to be discoverable. It can't be hidden. If I tried to claim an easement, for example, and this is a terrible example, but I'm going to say, if I was doing something in a heavily forested area that no one could possibly figure out that I was ever doing that, and I try to claim, oh, I have an easement to use that area for that purpose, that's probably not going to meet the open and notorious standard. It doesn't mean that the landowner has to actually know about it, but there has to be at least a possibility that they could figure out based on some sort of reasonable diligence. It can't be something that would just be impossible to figure out. Continuous use, the standard is 10 years. There has to be an element of continuous use of the easement area for at least 10 years. It has to be repeated. It can't be sporadic. Interestingly, it can be seasonal. And that gets into some nuances that we're not going to go over here, but consider circumstances where no one would use the easement area in the winter because there's a lot of snow, but they would use it all the other months of the year. If someone is using that easement area continuously, 9 months out of the year, every year for 20 years or 10 or more years, but they would never use it in the winter because you physically can't, that could still potentially open the road up for a prescriptive easement, even though in the strictest sense, it's not continuous because there are 3-month gaps every year, right? But in the course of over that period of time, you still have the sort of regular, non-sporadic, continuous, often repeating use to establish it, and the only breaks are because the breaks are they're understandable and perhaps even necessary for the type of use that's happening. And then there's the exclusive use, as I call it. So the difference here, so with adverse possession, as I said before, you have to actually exclude the property owner from the area being adversely possessed. Here, the difference is that it requires that the property owner not unreasonably interfere with the use of the claimant. So it's not the claimant excluding the landowner, but rather that the landowner doesn't unreasonably exclude the claimant. So they still call it exclusive sometimes. Oftentimes courts will call the factor or the element, the use occurs with the knowledge of the owner who could have asserted right of ownership, which is very catchy. But basically that's sort of the equivalent there. And so, this again comes with a great example is a private road. If the landowner and the claimant both use the private road and the claimant's been using it for 15 years or something, that would defeat adverse possession because the landowner is using it too. But there could be an exclusive, or I'm sorry, there could be a prescriptive easement claim because the claimant's been using it during that period of time, and the landowner didn't exclude the claimant. And there are nuances to that where I'm not saying that exact fact pattern would result in a prescriptive easement and not an adverse possession. I'm just saying there's a difference in those standards. A lot of these examples are very general. And I think it goes without saying that every case is very particular down to its facts and the applications of the law. So, again, if you've got questions about any sort of circumstance, feel free to contact legal counsel or contact us to talk about it. I'd love to be available for that. But the point is that these are sort of as general rules that's how it goes. And there is a difference between exclusive and adverse possession and exclusive, if you will, with a prescriptive easement. And then for uniform route, this is sort of an additional element that courts will often mention, especially in ingress and egress easements. The basic idea is there a uniform route that can be established with certainty, right? If I'm just walking, through my neighbor's property for 10 years, but I'm using 15 different routes and it's never consistent, and I walk here and I walk there, and I can't with reasonable certainty describe to a court where it is I'm going, and there's no pathway, and there's a lot of problems with this particular example then, right, in terms of trying to establish an easement. But the idea is to say, if there's, again, in the ingress, egress, in and out circumstance, if you've got a clear road that you've been using for 10 plus years, and that can be clearly identified and established with certainty, that will probably or very well can meet the uniform route requirement that courts will often put in for this particular type of circumstance. So those are the elements of a prescriptive easement. Again, this is also a hot area of litigation that comes up. Even though a prescriptive easement, there's sort of the funny thing that it's legally established, but you have to really go to court to get it nailed down and ordered to exist through some sort of declaratory relief, unless you can settle the issue, or just use it undeterred and nothing ever comes up, if only. So estoppel, this is perhaps the least common ground that I see. I'm not going to spend a lot of time on it. It doesn't come up a lot in my experience, but it does come up every now and then. Courts disfavor this, so you have an uphill battle. But it can be established through clear, cogent, and convincing evidence, which is of high standard. 3 elements. So there has to be an admission, statement, or act inconsistent with the claim afterward asserted. So again, I've basically acted in a fashion to lead my neighbor to believe they have an easement, and now I'm taking an inconsistent claim to that. The other party has to act on that, on faith on that, and there has to be injury from allowing me to now change my mind and say, no, you can't do that. So me repudiating that statement, act, or admission, and injuring the other party in doing so is critical to establishing. The burden obviously rests on the party that's saying there is estoppel. That's the claimant seeking the easement. I think that's not surprising. And then interestingly, there's a deceptive silence. It can be sufficient if the silence is a fraud, intends to mislead, and actually misled, and the silent party knew or had reasonable grounds to believe that the other party would act and rely on that silence. So, I mean, this is not necessarily an example that wins the day, but if another party were thinking that they had an easement and acting on it and repeatedly telling me, notifying me, writing to me, showing to me that, hey, I'm using this, I'm going to use this, starts doing work and gives me notices and all those things. And I just say nothing. I mean, they're like over notifying and doing all the things they can do. And I just silent, and then let them, do a whole bunch of construction, whatever they're going to do. Again, this is sort of a serious hypothetical that I'm coming up with on the spot that requires a lot of analysis and factual detail. But the point is to say that the point is the concept, which is that a lot of things are happening. I know the other party is relying on it and expressly relying on it. And I know that I'm misleading them by saying nothing. or I reasonably should believe that, there could be a case for estoppel. And then finally, we've got easements by implication. This is where there's no written, again, there's no express easement, and the elements of prescription are not met. This is an easement by implication. There's two types. One is prior use and necessity. They are very similar. They both involve the conveyance of a property. So this is where you've got two properties that had common ownership previously. And the easement is implied by the facts and circumstances surrounding that conveyance. And these can get very fact heavy. So we're not going to have, heavy facts on this just for to spare you. But the point is that it involves, like I said, it's sort of a common grantor, if you will, and it gets transferred to two different property owners, and then you deal with the circumstances around that. So they are very similar, prior use and necessity. Prior use has 5 elements. So there's a landowner who has to convey a portion of the landowner's land. And by the way, one of the two parties that own the two properties, the original landowner who owned both is often one of those. So the landowner, so that's the first element. The landowner must convey a part of the landowner's land, and the landowner must retain a portion of that land, right? So they're one of the two. Typically an adjacent parcel, makes sense. There was usage between the two parcels prior to conveyance that would have required an easement had they been separate properties. So that's critical. Basically saying that the landowner was using the two properties. For example, there could be a roadway or something through them, but the landowner was using it in a fashion where if they were not owned by the same person, you would have to have an easement. And the easement must be reasonably necessary to the property that would benefit from the easement right. So I'm the landowner, I convey I have two parcels, they've been divided, I convey one to someone else. There's use that I was using between them that would have required an easement. Now that someone else has it, they would need an easement to be able to do what was being done, and there must be reasonable necessity. Reasonable necessity is not the same as strict necessity. Necessity doesn't mean what people often think it means is that this is it. If I can't use this easement, I'm going to be landlocked. I can't get to the road. I'm going to be stuck in my property forever. It's not that level. It's reasonable necessity depends on whether the claimant at a reasonable cost can create a substitute to the implied easement. And reasonable is a sliding scale. This is where it gets really fact intensive. Of course, we're going to look at what the cost is to have a substitute, all those kinds of things. And then the use has to be apparent. Often, again, this is why we talk about driveways and roadways a whole lot, because there's sort of the proof is in the pudding. If there's a roadway there, what is it for? And so for less obvious usage, though, you can sometimes still show apparent use if you can see sections of it, which is kind of funny, but appliances or portions of an underground line, something that would show someone walking there, oh, there's use there. And sometimes a written discussion, if there's some evidence, emails about this particular use, that can sometimes help. Courts will sometimes refer to this as a quasi-easement that existed before the conveyance. This is in part because you, as a landowner who owns two properties next to each other, you really can't have an easement with yourself. So it's not an easement, but they'll say quasi-easement, just for purposes of making it make sense, I think. And then there's easement by necessity. The 3 elements here, again, the first 2 are the same. The landowner must convey a part of the landowner's land. The landowner must retain a portion of the land, typically, again, the adjacent parcel. And after severance of the parcels, or conveying one of them, it is necessary to pass over one of them to reach a public street or road from the other. And this is interesting because there doesn't have to be prior use. That is the biggest difference, I would say. And the easement by necessity arises when the parcels are severed. And so you don't need the prior use part, so it's a little bit, there are fewer elements to meet, but the need arises when it's severed, so that's why you don't need the prior use, because kind of, the courts are saying, it comes up right when that transfer happens. But, it's necessary to pass over one of them to reach the road or public street from the other, so it's kind of specific. And the test, again, is similar, right? When you talk about necessity, it's the reasonable cost. Can you find a substitute that doesn't require trespassing, or is it going to be exorbitantly expensive? Again, it's not strict necessity. It's kind of a substantially less convenient standard, if you will. So that's the sort of fourth ground, if you will, or 4B of how to establish easements. You have express easements, you have prescriptive easements, you have easements by estoppel, and you have easements by implication, both in terms of prior use, that's 4A, and necessity, that's 4B. There's also a statutory procedure for easements by necessity, private condemnation. I'm not going to go over that today. Right now, I'm really looking at the common law, but there's a statutory procedure for that, and there's a whole host of elements that have to be met in order to establish an easement through the sort of statutory scheme. What I'm talking about is generally developed through the case law, and of course in the circumstance of express easements, just through written documentation that we've seen, and of course interpreting that over time. So if you have any questions, I've got my contact information up on the screen. Feel free to shoot me an email or give me a call. I'd be happy to set up a time to chat with you. As I said, our firm handles all sorts of different real estate matters, including those involving easements, from creating them, interpreting them, terminating them, litigating over them, negotiating over them, and easements of all kinds, whether it's an easement for ingress and egress, or an exclusive use easement to use a yard, to prescriptive easement to access a public road that you can't get, that you've been using for many periods of time. All of the above, as well as just boundary disputes in general. We have handled a large number of those over the years. And if you have any real estate issues that come up and you need assistance, certainly contact me. And I hope that you made it through the whole presentation today and that you found it informative and enjoyable. And I thank you for your time. I appreciate it.